And good evening, everybody. This is Vinny Milletti with Milletti Law, the strongest name in law. I am Vincent Milletti. I am the owner, founder, partner, lead principal, lead attorney, God King, everything in this place in Milletti Law. First and foremost, I'd like you to start by going to the subscribe button you see there on YouTube. Make sure you subscribe to the channel. Remember, the more subscribers we get, the cool things we could do with YouTube. So certainly, I'd like you to do that. And as soon as when we get to a certain number, we can start like branding, and it's just really cool. Also, go to the website www.millettilaw.com, www.millettilaw.com. Make sure you sign up to the newsletter, and this way you're always in the know. We have content, fresh content that's being delivered daily. I got my team on full blast all the time. We got blogs, we have articles, we have Facebook, Instagram, videos, all kinds of stuff. So, definitely make sure you're in the know. Definitely sign up for the newsletter. Definitely subscribe to the channel. And, let's get down to it. So today, right now, it is November 17th, 2021. The title of this video is The Rule of Six in Litigation Funding. The Rule of Six in Litigation Funding. So this is actually a really interesting video because this is becoming very big in the industry outright. So, as you all know, sometimes litigation is very expensive. Milletti Law generally is cheaper than most people, but still, litigation, it costs a pretty penny. I've seen budgets, even, from the defense side, I've seen budgets between, $300,000 to $700,000 to $800,000. Plaintiff side budgets, I've seen very high budgets for plaintiffs. Contrary to what most people think, there isn't this invisible fund that you could just pull money out of and that's it, just money's there and it just covers it. No, people, you pay a lot of plaintiffs, unless there's a fee trail, unless there's some kind of like fee shifting provision, and unless there's like a known insurance carrier in place, most plaintiff attorneys are not getting involved. If there's an insurance carrier, you have a big pot of money at the end of the tunnel. Insurance carriers love to settle, and fee shifting means attorneys can get their money back. Many, if not most of the cases are not like that. Most of the cases are not like this, and there's really, it becomes a heavy burden sometimes, right? So enter litigation funding. Litigation funding. So let's go through a couple of questions. What is it, right? So litigation funding or litigation financing, that's when a third-party financier, funding company, venture capital, some kind of third party comes in and picks up and covers the litigation expenses. So, litigation, like I said, it was expensive, right? So this third party comes in, says, hey, we notice your budget. It's a $500,000 budget. We're interested in this. Let us know, right? So that's basically in a nutshell. It's a third party finance. It's a third party that comes in and finances litigation. Sometimes the plaintiff defense side, whatever litigation has a good outcome in the end. So question is, why do it, right? Obviously, this is the first rule of six. Especially for litigants, right? First and foremost, it's non-recourse. Most of them, any reputable litigation funding company is going to be non-recourse, meaning that if they agree to take on a case and they lose or whatever, there's a problem. Let's say, you're a plaintiff, you want to sue Milletti Law because Milletti Law is just the world's greatest corporation, and that just has $1 trillion in a fund somewhere. And, you want to sue me, litigation financier, hey, the case is worth $100 million. Yeah, we'll cover your attorney's cost, right? So if they fail, it's non-recourse for the most part, right? So non-recourse, it's risk reduction for the claimants. Basically, they don't have to worry about it. If it's non-recourse, they're just going to push, and if worst case scenario, they fail and lose their case, that's it, they're out, So it's risk reduction for the plaintiffs. This is really something that works very well for principled plaintiffs that have strong brand power, right? So whereas you're really pushing this for you're really pushing something, let's say, to protect your brand. Let's say, as you all know, I just got a new dog. His name is Flex, right? Well, what if I decided to have, the Flex brand of Milletti Law, right? And now suddenly somebody else comes along and has a Flex brand. I sue him for infringement. Let's say I have this really great case against him and I'm entitled to win $100 million in my case. But realistically, let's say I don't care. Let's say I'm really more concerned about the brand. I'm not so much concerned about, I'm not really concerned about recouping any of my money back. So what I do, maybe I want to go to a litigation funding company because, they'll float the fees, they'll get the firm, they'll pay and take care of stuff. And then all I got to do is supply the facts, right? So and I really want to enforce my brand as it is. So it's really best for principal brands, principal plaintiffs It also helps serve as a reality check for plaintiffs. A lot of times you think your case is worth $100 billion. It's really not, So it also serves as a reality check because the financier will come and go, no, this is not worth all this money, right? So also, it allows the plaintiff to focus more on the litigation and less on trying to find funding, right? So it allows you to focus more on litigation, less on trying to find the funding. You could really narrow it down. And then finally, the sixth part of that, because remember the rule of six, the sixth real big benefit is simply it's a very high upside for the financier. Generally, you'll see returns about 3 to 4 times your investment. I've seen situations where 7 to 10 times their investment for financing companies, when it's successful. So the rule of six here is, the first rule of six is, why is it desirable? It's non-recourse. It's a way to reduce risk. It's desirable for principal brands. It serves as a reality check. It permits you to focus more on the litigation versus the funding, and it has a high upside for the funders. So that's the first rule of six. So now he says, who controls, when it comes to always in litigation, right? It's who controls litigation. Sometimes between you and your insurance carrier, who controls the attorney. It's between you and whatever funder, who controls the attorney. It's who controls the pace of litigation, right? So any reputable funding company will want to remain neutral and passive, and will want to have an independent attorney working on their claims. They should not be getting involved. They should not be demanding any kind of control litigation, because a couple of reasons. I mean, one, obviously for the conflict issue, and two, also because now your interest, now the funding company's interest is not aligned with the same interest as the claimant, right? So, I mean, you don't have to have perfectly aligned interest, but you should at least be, have some aligned interest. So the question is, who controls litigation in litigation funding in this kind of situation? You really want it to be the independent attorney that's retained on your case, or that's representing you on your case. That's really the one who needs to be controlling it, not the funder, and actually not the claimant. So keep that in mind, right? Next question is, well, when is a case desirable, right? So when does a funder say, hey, we really want to take on this case. We really want to fund this litigation. Keep in mind that only about 3%, I want to say between 3 and 4% of cases actually get funded. Most people are rejected, because, and again, the reality check, because claimants think their cases are worth $400 billion, and they're really not. They're worth garbage, So, but whatever. So when is this desirable to the funding company? And this will be your second rule of six. Because remember, the rule of six. This is your second rule of six. So your second rule of six is you look at 6 specific categories to determine whether or not a case is desirable to a funding company. The merits of the case, obviously, if you're a legitimate claimant, you have a real case with a strong, a likelihood of success. The motivation of the claimant. If you're just a vindictive jerk, they may not want to take you on. If you're irrational, they may not want to take you on, right? So what is your motive? What's the claimant's motivation? What's the claimant's desires? Remember, I remember my position is, this is great for those who have a strong brand power, plaintiffs with strong brand power. The third is basically the claimant's attorney. Who's your attorney? If you have a really good, powerful attorney that wins cases, you're going to be more desirable to the funding company, right? Because they go, hey, this girl's got a really great attorney. That attorney beats people down pretty bad. We're going to, we feel good. We want to fund that, right? So that's another thing. Proper budgeting is number 4. They should have a proper budget on hand. Budgeting is critical. There has to be a budget to begin with. Though I've yet to find, and maybe I'm just not that complex, but I've yet to find a litigation financing company that really can't afford a budget that comes in. So usually, a lot of litigation finance companies, they're kind of like hedge funds almost. They got a lot of capital, a lot of venture capital to go around. So they're very well equipped. Stop touching the camera. Damn dog. All right. Oh, come on, buddy. You want to come to the camera? So where were we? Okay, come on, Flex. All right, so you're all getting a treat in this video. Now we have Flex. Okay, Flex. All right, buddy, what do we got here? So now, where were we? So we have the proper budget, right? Number 4 is a proper budget. Now we have damages, right? So what do your damages look like? Are they high damages? Are they low? Obviously, you want high damages. The higher your damages are, the more desirable you're going to be to a funding company, a litigation financier. 6, the ease of recovery. So that's the 6th element of this. So let's say there's a term in the industry called judgment proof. So let's say, you're the claimant, you sue somebody, you have a great case and the numbers are huge, and like you're definitely gonna win. But the reality is they're judgment proof, they're gonna go into bankruptcy, let's say, they don't have any assets. So what do you do? So that's another consideration. So the second rule of six, because remember the rule of six in litigation funding, the second rule of six is it's 6 criteria to make the case desirable. All right, so that's the second rule of six. And now the final rule of six we're gonna go through, you're going to find it in how do these relationships work, right? So basically, what is the contract between the claimant and the funding company? And here's the other rule of six for that. So I did write this down. Sorry, Flex. Let me just make sure I have my notes here. Yes, buddy. Yes. Don't destroy Daddy's headphones, because Daddy needs to talk on this camera. Yeah, good boy. Okay, so I'm just going to hold him here. Okay, so let's go. Let me just double check. All right, so the rule of six for the third part. Okay. So my notes, 1, definitions, right? So how does a relationship work? Another rule of six, 1, definitions. You have to understand the terms of the agreement. Who is a claimant? What's litigation? What's termination? What's the term? Is it recourse? Is it non-recourse? They should all be non-recourse. If you have any that's recourse, then your funding company's a fraud, So definitions and terms are going to be critical. Also, how is it funded? Again, most of these companies are venture capital companies. They have a lot of just cash on hand to begin with, funds on hand to begin with. So that's big, right? Reps and warranties. What representations and warranties do they want you as a claimant to make? You probably have to attest to your corporate structure, your corporate existence. You have to use good faith in everything, that you don't have any other litigation going around, or whatever the case is, no other risk. So that's big. So your reps and warranties. Also, another critical element is the termination, right? So what happens when the relationship terminates? When the relationship, or what determines what determines when a relationship is terminated, right? Sometimes, for the most part, it's gonna be, if you can't come to an agreement, let's say, between how you want to resolve a case, that might be an instance where your relationship comes to a termination. If you're not complying with the attorney that is part of the fundraising, that's going to be an issue that leads to termination. So that's another thing you want to consider. There's one more item here. I'm sorry. And then also 2 more items, actually. The distribution of the proceeds. How do the proceeds get distributed? So that's huge, right? So who gets repaid first? I mean, obviously the funding company, that's probably a top level return, right? So before you even allocate anything, they probably get their money back returned. There's probably some number that they entitle themselves to, whatever the case is. So that's something you might want to consider. So how do the funds get distributed? What's the priority of the distribution of the funds? It's very important. And finally, covenants and promises that you make. Obviously similar to reps and warranties, but reps and warranties are very like boilerplate language, standardized things, right? So for instance, you're not currently in default. That's a warranty. You're not currently under investigation by the federal government or by the SEC. That's a warranty, right? Covenant, those are promises that, just, in other words, covenants are going to be your terms, just your terms of the relationship, right? Your paragraphs. Parties are going to use best efforts to resolve issues. Parties agree to go to arbitration if there's a problem, or whatever the case is. So that's your rule of six there. So to go about it again, the rule of six for how the relationship works in contract between the parties. The rule of six is, it's what are your terms and conditions, funding issues, reps and warranties, how the relationship ends in termination, how the funds are distributed once there is a payout, and then also covenants and promises you make. So hopefully this video wasn't tremendously distracting for you, as it was pretty distracting for me, but I'm at this point now where I am immune to annoying pets and family members interrupting me and everything. But today was no family members, it was just pets. So, okay, so there you are. So that is the rule of six in litigation funding. Just to kind of leave off with this, I think litigation funding is a great thing. I think it does a huge job helping. It has a great benefit and upside to really everybody that's involved. I think it's unfortunate that, it's only 3%, but I mean, you're talking about real money, and people want real returns. So, I mean, hopefully down the road, this is an industry that grows. People could, maybe investors want to take on a little more risk. I mean, there's some seriously substantial cases out there that need that could really use this. And I'm talking about infringement cases, talking about cases involving companies that put in the bad products in their, putting bad ingredients in their products, etc. So, I mean, litigation funding definitely has a home, and it should be growing. And, it's generally a good thing. Just obviously, like everything in your life, make sure you're making right and smart decisions, and make sure that, you're not getting taken for a fool. You're reading contracts, and you're actually telling the truth, and you're aligned on items, so you don't find yourself in trouble in the future. So hopefully this video was informative. Hopefully you got a good sense of what you need here. A blog will probably follow up on this. This was a lot of information, but this was the rule of 6 in litigation financing. With 6 criterion, 3 important parts. The 666 of litigation financing, a very appropriate number and very appropriate reference for an attorney in a law firm. So, as always, yours in Laws, Love, and Lifts. This is Vinny Blay with Maletti Law, and that was Flex. That was in the camera, me interrupting, and you have a wonderful week and a weekend ahead.